good afternoon, everyone, and welcome to today's event, From Draft to Implementation, Preparing for the EU General Purpose AI Codes of Practice. My name is Michaela Sullivan-Paul, and I will be moderating today's important discussion. On behalf of the European Institute for Public Administration, or as we like to call it, EIPA, we are delighted to host this event, bringing together experts to explore the role of the codes of practice for general purpose AI models in shaping AI governance in the EU and possibly beyond. For those unfamiliar with EIPA, we are a center of excellence for training and capacity building on European policies and administration. Our mission is to equip public officials and professionals with the knowledge and the skills needed to navigate EU regulations, policies, and governance frameworks effectively. Given the transformative potential for artificial intelligence, both as a driver of innovation, but also as a regulatory challenge, our work increasingly focuses on ensuring that public administrations have the necessary tools to understand and implement AI governance mechanisms to advance their own digital transformations. This event comes at a critical moment, not only because the third draft of the Codes of Practice for General Purpose AI models was published just yesterday, but more generally because we now have moved into a phase of the EU AI Act's implementation, which sets clear obligations for AI providers and deployers and developers. However, as AI capabilities evolve rapidly, policymakers have recognized that additional flexible, practical, and enforceable guidelines are much needed to ensure compliance and to mitigate risks, particularly when it comes to general purpose AI models. And this is where the codes of practice for such models comes in. The codes of practice are currently being developed as a voluntary, but nevertheless, highly influential governance tool to support compliance with the EU AI Act. And the aim of these codes are to provide concrete guidance on how general purpose AI developers and providers can meet the AI Act's obligations, particularly regarding systemic risk mitigation, transparency, and copyright issues. It also aims to address systemic risks associated with advanced AI models, ensuring that they do not undermine fundamental rights, democracy, or public security. And finally, it serves as a basis for future regulatory measures, potentially paving the way for an implementing act that would make key elements of the codes legally binding. In the case that the AI Office deems the codes adequate, signatories can use their adherence to the codes as a presumption of conformity with regulatory requirements, and thus the codes are recognized as playing a key role in supporting legal compliance, enforcement strategies, and cross-border regulatory cooperation. However, the drafting has not come without its controversies. From the very beginning, we have heard concerns regarding who is and is not involved in the drafting processes. Only yesterday, the penultimate draft of the codes were shared, providing a clear picture of what to expect in the final draft, expected for early May. And already, conversations have begun highlighting the draft's divergence from earlier versions on matters relating to copyright, transparency, and whistleblower measures, for example. This leaves many to wonder about the viability of the codes if AI companies and developers fail to agree on the scope of the codes for general purpose AI models. So, whether you are working in public administration, AI governance, legal compliance, or policy implementation, these codes of practice will undoubtedly shape the future of AI policy in this landscape and possibly beyond. Understanding how they are being developed, what challenges they aim to address, and how they will impact AI adoption is crucial for both private and public sectors, policymakers, and professionals alike. This event brings together three critical experts who have been directly involved in these discussions relating to AI governance here in the EU, and particularly with relevance to the codes of practice. They have been invited here today to offer their invaluable insights into different aspects of the codes of practice. So without further ado, please allow me to introduce you to today's panelists. Starting with Demetrius Flautis, who is an international lawyer and policy advisor specializing in tech and is an AI governance expert and theorist. He is currently a visiting scholar in law at Downing College with the University of Cambridge and a member of the university's AI at CAM group. He is also an affiliate professor at the AKBFU, where he lectures on artificial intelligence regulation, a fellow of the Hellenic Institute of International and Foreign Law, and a practicing legal counsel. He has worked for many years as policy and geopolitical advisor to cabinet-level decision makers for several governments and consulted numerous international think tanks and organizations. Demetrius is a senior advisor at the Cambridge Existential Risk Initiative, the editor of the Nuclear War and AI Law sections of the Phil Papers Academic Repository, and on the review board of the AI Policy Bulletin. He's currently working on a blueprint for the UN-backed Frontier AI Control and Non-Proliferation International Treaty. Thank you so much, Demetrius, for being here. We also have Maria Orerozeli-Koutsouphia, and Dr. Maria Koutsouphia is a qualified lawyer in Greece and Belgium with extensive experience as an AI legal expert in Brussels, including working at top-tier US law firms focused on healthcare and medical technologies. She is currently working as an officer at the European Research Council for the European Commission, and she has been appointed as one of the national representatives of Greece at the EU AI Board subgroups. Maria holds a PhD in information law from the University of Athens Law School and has completed 3 master's degrees in law, one on public law, one on international legal studies, and one on intellectual property, information communication and technologies from the University of Athens and KU Leuven Law Schools. We're very lucky to have Maria here to present her personal views on these matters. And finally, Lucas Adamovikis. Lucas serves as a Global Privacy Policy Analyst at the Center for Information Policy Leadership, or CIIPL. In this capacity, he specializes in the EU legislative framework concerning data protection, privacy, regulatory engagement, and digital strategy. Lucas actively engages with senior leaders from industry, regulatory authorities, and legislative bodies to develop global solutions and best practices for privacy and responsible use of data. Prior to his role at the CIPL, Lucas was a data protection specialist and research assistant at EIPA, so we're very lucky to have him back, and previously also with the European Center for Judges and Lawyers. He holds an LLM in European Public Law and Governance from Maastricht University and a Bachelor in Political Science with a minor in European and International Law. Thank you all so much to our panelists for being here today. We are truly fortunate to have you joining us here for today's event. So just as a primer of what we can expect, the following event has been divided into 3 distinct segments, starting with one that aims to really build understanding about general purpose AI models and the codes of practice themselves. The second segment will touch on the development process and the possible implementation challenges we could anticipate associated with these codes. And the final, a discussion on next steps and the implications of the codes of practice in a larger, more broad landscape. Each panelist will be given roughly 3 minutes to respond to their question, and we kindly ask our panelists to do their absolute best to stick to their time limit so that we may have sufficient time to open the floor to you, our audience. At the end of the panel, we will host a Q&A session moderated by my colleague, Layla. And as such, we encourage you all to submit your questions via the Q&A function on Zoom throughout the entire discussion so that we may address them during the Q&A period. So with that, I say we go ahead and jump right into our first segment. So the EU AI Act introduces a very unique approach to regulating AI, particularly when it comes to general purpose AI models. Unlike traditional sector-specific rules, the Act ensures that general purpose AI developers take responsibility for both the quality and compliance of their models before they're deployed in AI systems. And so this has naturally created a legal distinction between general purpose AI models and AI systems, where general purpose AI models can be considered these foundation models that can perform a really wide range of tasks that can be adapted for various applications, but not necessarily serving specific functions until they're integrated downstream into AI systems. By contrast, AI systems, those that are subjected to these prohibited or high-risk classifications, they're considered end-use applications which apply these models in a defined or specific context. As Gaia Marcus, the director of the Ada Lovelace Institute, puts it, general-purpose AI models function as the engines powering countless downstream applications. Just as we regulate car engine safety standards rather than individually certifying each vehicle model built with that engine, the code here provides assurance for the models that form the core of thousands of other AI applications. So as such, the AI Act introduces different regulatory requirements for each. General-purpose AI developers must ensure things like model transparency, robustness, and compliance at the foundational level, while AI system deployers bear the responsibility for things like risk management or impact assessments and compliance in their specific use case. This layered approach is designed to really ensure that there's accountability at both stages of AI development and deployment. However, not all general-purpose AI is treated the same. The EU AI Act goes even further in categorizing general-purpose AI models according to the systemic risks they pose. As such, some obligations apply to all general-purpose AI models, while others only apply to AI models that pose systemic risk, while others, like free and open source models, are exempt from certain obligations altogether. So to kick us off, Lucas, can you provide us an overview of who exactly these codes apply to and which actors, whether public or private, really stand to benefit from the adoption of these codes by its signatories?
Thank you, Michaela, and thank you also for the other panelists for joining this webinar. It's a pleasure to be here. As you already mentioned, my name is Lucas Adamavicius, and I'm from CIPL. We are a global data and privacy policy think tank, and we've been involved in this process since the very beginning. We are, of course, part of all 4 working groups, and we've been very actively engaged in the process of the AI Act in itself and drafting of it. So to answer your question, perhaps in a cheeky manner, I would say that the code benefits everyone. Frankly, just because of the nature of the technology that we are talking about and the benefits that GPAI models bring to our society and everyone. You know, as you mentioned yourself, GPAI models can be used in such wide variety of tasks, and they're extremely beneficial for, you know, numerous organizations, but also in EIPA context, I think in particular public administrations, there is a lot of potential to use GPAI models, and I think that public administrations can definitely use those models to increase their efficiencies and provide better public service. But to get into more detail, frankly, GPAI Code of Practice is designed to provide a way to show compliance and evidence that compliance for GPAI model providers to the outside world, also trickling down to the downstream providers and deployers. But to be more specific, frankly, the code applies to GPAI model providers. So these are the companies that develop and place the AI models on the EU market, whether they're headquartered in the EU or not. Then we have the specific obligations for providers of GPAI models with risk. So they face enhanced obligations related to safety and transparency and security. And I think a small caveat that I would mention here when it comes to GPAI models with systemic risk, we need to somewhat understand that, you know, most likely these are the models that bring most of the benefits as well. These are the most capable state-of-the-art technologies that benefits the users. So, you know, when we are talking about these additional obligations, we should also very much be careful in thinking about how to balance those benefits with those obligations and make sure that the balance benefits us. And also because that systemic risk can appear just because of the reach, scale, and scaffolding effects of the model in itself. And of course, the code does have impact on downstream AI system developers. While they are not the primary audience of the code, but it definitely has impact on them. And it also has impact on regulators and policymakers or the same public administrations that will be using the models. So when you think about public procurement in terms of acquiring those models, it will help public administrations because they can rely on a more or less standardized information that they receive about the model, and they can make better informed decisions. So again, I think to sum up, the benefits are evident to providers. They have a clear way to show how they comply. And also, it shouldn't be forgotten that AI Office takes into account the adherence to the code in terms of their enforcement actions. So this can be a measure which will alleviate some of the enforcement aspects and would be looked at favorably. So I think that's an important aspect to mention. Of course, the regulators also benefit from it because they have this kind of structured enforcement model. They know what the companies are expected to do. So it makes their enforcement easier. And of course, the public, because it does provide greater transparency. And I think in particular, this whole process of drafting the GPAI code of practice does benefit the public. And because of the scale of involvement of stakeholders and the ability to provide feedback and get involved in the actual drafting process.
Thank you so much, Lucas. In particular, I like this kind of notion that indeed these codes are really designed to make enforcement easier and to introduce kind of a structured approach to some sort of compliance. And I think that actually moves in nicely to my next question, which here is going to be directed to Demetrius. So with the AI Act imposing these numerous obligations on deployers and providers of AI in conducting impact assessments and ensuring transparency for high-risk AI systems, there are growing concerns about how these requirements will shape administrative procedures and possibly complicate already very complex operations. And we see with the the European Commission's 2025 work plan, there is a promise to simplify legal processes and compliance measures relating to EU digital policy, which I think kind of signals a recognition of the challenges that implementation can pose, particularly when we're talking about digital regulation here in the EU. In principle, this notion of co-regulation can be very much a useful instrument for reducing legal uncertainty when it's designed and used as compliance tools. We've seen this with the likes of the GDPR's Code of Conduct framework or the codes of practice on disinformation, for example. And so, Demetrius, I'm curious, do you see the codes of practice for general purpose AI models as an effective mechanism for streamlining legal compliance for AI providers? Or in your opinion, do they introduce new complexities? Where do you see, or do you think there's, opportunities for further clarity or improvements with these codes? Thanks. Sorry, Demetrius. I think you're still on mute.
Michaela, no new complexity is convoluted enough to even scratch the surface of regulating the headlong AI race that we have found ourselves in. I believe that we have all observed that progression has been accelerating in the last 6 months. And for that reason only, this discussion about stifling innovation or being able to choose between safety and innovation, I believe has no point at all. Everyone sees the innovation happening all around us. You mentioned the third draft of the Code of Practice, which came out just yesterday. And it's, in one word, it actually shows that the European Commission and the drafting committees have actually listened to the fears of big tech companies and their lobbying groups. And they have decided to follow United States and United Kingdom into this let's support innovation idea. For instance, the day after the Paris summit in February, the AI liability directive was shelved. That, for many of us, is catastrophic, because this was the only thing that AI majors were worried about, and probably the only way that we could possibly get them to comply and be much more risk conscious. Now, we have to remember that the AI Act was originally designed before the advent of ChatGPT, and it had no targeted provisions for the suddenly ubiquitous GPAI models. These came into revisions towards the end of its long drafting process. For the second draft, even Eurotech, not only the US big tech, have said that it imposed excessive and impractical obligations. For instance, complex regulations, unfeasible compliance measures, controversial copyright provisions, excessive disclosure agreements, what have you. These were additional burdens on AI models, which they, as they claimed, went beyond the AI Act. I will actually mention later in another segment about whether we should be going beyond the AI Act or not. But let's remember something. The codes, and in particular, the parts of it which apply to safety, apply almost exclusively to the largest tech companies in the United States. It does not have any application to any European companies. I believe there's only one EU-based company that would fall under the high risk, the systemic risk products. So it was based on what Lucas just mentioned. It was an opportunity for the European Union to actually seriously kickstart its downstream AI application system, relying on checks and balances upstream to foster trustworthy adoption for us and promote Europe's tech ecosystem. The reason for that is that most European companies actually build applications on top of GPAI models, so stricter obligations higher up the value chain would benefit us. And what we have now instead is a new draft, which is full with terms like best efforts and reasonable measures and appropriate measures, and no strong commitments whatsoever.
Thank you so much, Demetrius, for that. It's an interesting point, this balance between innovation and regulation, and I'm happy that you touched on it, because it is something that I would actually like to elaborate on a little bit further, especially given that the earliest discussions on EU measures to regulate AI has really entertained kind of this back and forth debate about regulation and innovation, and has very much dominated kind of the discussions around the EU approach to AI regulation. We even saw this, as you've mentioned, at the most recent AI Action Summit that took place in Paris just last month. This is unsurprising that this narrative continues, keeping in mind kind of the current political climate, but also new kind of initiatives of prioritizing EU tech sovereignty, for example. So with this in mind, I would be curious to hear, Maria, your thoughts. How do you see the codes of practice contributing to this balance of innovation and regulation, if at all? And is there a way that these codes can support the EU's competitive strategy on AI and really help kind of foster this technological sovereignty that we keep talking about?
Thank you, Michaela. I'm really happy to be here with all of you, and I will go straight to the answer. So I, and my personal opinion, and I think that many of us can say that the exact goal of the codes of practice is balancing innovation and regulation. Otherwise, we would have just used the AI Act to provide all the regulations and all the guidance that we needed, and it will all be there. But it's a choice from the regulator to continue with codes of practice, and that choice was exactly to help innovation participate and to show Europe's flexibility towards innovation and towards the industry that really had to participate in this dialogue, I would say, during the drafting. Although, yeah, many things have been said about who participated and who did not. Well, my personal view would be that it was open. Well, the call was open, and anyone who really wished to participate was there, and I understand that major players were there indeed. Now, I would like to point out two things on how, as ways of the codes of practice supporting innovation and, as I said, innovation through regulation. That's my idea of how Europe innovates. So first, as you said, the main pillar is transparency, right? Transparency is one of the commitments of the GPAI code. The other is copyright. So let's start with transparency. How does that help innovation? Well, transparency means documentation. Documentation means that the downstream users, the AI systems, manufacturers, deployers, providers, would have the certainty to create, so to innovate. And as you said, in Europe, that might not be the first goal of the GPAI code, but indirectly, the whole Europe is affected by the GPAI code in terms of helping downstream providers integrating AI safely. And of course, it allows regulatory bodies that, I don't know, tomorrow it's going to be national authorities, today is the AI office, to audit, to check the systems. So if we don't have documentation in place, none of these things can happen. And without checks, there is no trust. And I think that trust is a key point for innovation nowadays, because innovation can happen anywhere, anytime, with any way. But trust is now what we need in our society, and what could help us adopt AI. The second pillar, very, very briefly, it's the copyright pillar. So how does that help? Well, when you impose some obligations, some very fair, I would say, obligations, maybe, yes, as the previous panelists just mentioned, maybe complex obligations, copyright obligations, that could help, though, to prevent legal disputes. We have seen around the world that there are already many legal disputes arising about copyright. I would just mention the most famous one, the New York Times legal dispute for copyrights, but there are many more around the world. And that certainty of the GPAI models would alleviate any doubts. That could help the legal dispute end now and maybe for the future. And the other thing is that it creates certainty, it creates protection for creators' rights. In Europe, we have creators. Innovation is through creating. So we can't have our creators unprotected and left out there to be robbed of their products without giving them some weapons, some documentation, some trust, some protection to help. And by helping creators, we're helping innovation. Why? Because we're saying to creators that, look, if you create something in Europe, that will be protected and not stolen. So keep creating. Now they are losing their motive to create. So I would say that trust and motivation is building innovation. So that's how we are innovating through regulating.
Thank you so much, Maria. And I completely agree. I mean, these principles of transparency, all of these kind of mechanisms are truly in place to increase, trust both from industry, but also in the public. And I think this is one aspect of the conversation that has been scrutinized is kind of really the participation and the transparency of the drafting process itself. So with that being said, I do want to move into our next segment, which does kind of promise to kind of hash out this a little bit more. The drafting of of the codes of practice has been, I imagine, an intense and iterative process involving input from various stakeholders across industry, academia, the government, and oftentimes, I can only imagine, with very conflicting ideas about what works and what doesn't. So anticipating these complexities, the AI Office did establish various working groups to tackle different aspects of the codes of practice. And the consultation process has been, as already mentioned, both praised and criticized. On one hand, it has been recognized for fostering these kind of structured discussions around key compliance mechanisms and, the introduction of key performance indicators to measure adherence, for instance. But on the other hand, concerns have also been raised about the degree of inclusivity in the drafting process. Civil society organizations and policymakers alike have voiced their apprehensions about the influence of AI developers in shaping these voluntary commitments, warning that they could prioritize industry interests over strict compliance measures. Additionally, questions remain regarding the extent to which the codes will effectively support deployers in implementing AI governance measures. As a voluntary instrument, at least in its current form, there are concerns about how enforceable these commitments will be and whether they provide sufficient clarity for public and private sector entities seeking to navigate obligations under the EU AI Act, and whether the codes will be accepted at all. So Demetrius, based on this and having participated in the consultation process across 2 distinct working groups, you've had a unique perspective on how the drafting of the codes of practice has unfolded. So based on your experience, how inclusive has the process actually been of various stake and rights holders? And from your perspective, what are some of the considerations at play here when we're involving AI developers in the drafting of the codes themselves?
Let's start with a quote from a very senior expert who has said that having artificial intelligence industry self-regulate is like allowing children to run a candy shop. Quite a few people were initially, I wouldn't say surprised, but they were certainly not very happy that the big tech companies, as well as the lobbying groups, and as well as the representatives of industry would be included. On the other hand, it is true that their insights brought some practical perspectives, because it was one thing to say, yes, this is risky, and another thing then for them to respond, well, this is what's feasible, this is what is sound, and these are the practical considerations. So that was positive. At the same time, if we had them involved, the compliance rate that will eventually happen is going to be, we hope, much higher, because it has been taken with consideration to their own wills and fears. So we were trying for a mutual understanding. Now let's explain very briefly how the codes is being prepared. We are now, as we heard before, in its 3rd stage, because the 3rd draft has just been published yesterday. The whole publishing process, drafting process, is an iterative process. That means that we go step by step by step, and we discuss every step and vote on it. There is the plenary, which includes all experts, and 4 working groups on specific topics. In the working groups, the discussions are facilitated by chairs and vice chairs, and they are the ones who make most of the actual drafting after listening to massive inputs that have been coming their way. We also have a system of online voting, and we are representatives are given a number of multiple choice questions that, would you like this? Would you prefer that? And we vote online during the working groups and the plenary sessions. Now, the stakeholders involved are, of course, the general purpose AI model providers, the downstream providers, industry organizations, civil society, rights holders and copyright holders, other entities, as well as academia and independent experts. Of every every firm would have only one representative. So it wouldn't be that Microsoft is very big, so we have 10 representatives. There's only one vote from them. Now, the reality is that we have been having a running battle between the so-called risk conscious, who are the civil societies, the NGOs and academia, and the techno-optimists, which is essentially big tech, futurists, industry associations, and lobby groups. And we have to also take into consideration that there have been specific workshops that were only dedicated to the providers without the participation of anyone else. That is something which was already criticized several times at the beginning. As regards the previous draft that we had 2 months ago, Meta, for instance, had said that they will not sign it, and Alphabet threatened to do the same. Civil society was equally unhappy and threatened to withdraw from the GPAI Code of Practice altogether, calling it fake participation. That is why we had the third draft delayed by 3 weeks. And I can tell you that everyone is now braced for the mother of all battles in the drafting committees, because there's going to be some very tense negotiations out there ahead of the fourth, final and decisive round. We have lobbyists of all kinds who are already prepping for the last showdown over a document which will be quite difficult to agree upon. And whatever happens, it is going to leave some people and some groups unhappy, possibly all of them at the same time.
Yes, this feels like an inevitable kind of result, is that you can't find consensus and agreement about among everybody. But indeed, I think you did a great job at kind of highlighting where these tensions are and how we balance kind of these different interests. And so I am curious. I do want to turn it over to Lucas to hear from your perspective, since I know through your work with CEPOL, you have engaged directly with these general purpose AI developers and industry, specifically with regards to the development of these codes of practice. So some general purpose AI developers, to Dimitri's point, has kind of expressed their resistance to signing the code, with mention of kind of Meta, for instance. Here, there's clearly a very delicate balance that needs to be struck in these codes, where the spirit of the EU AI Act needs to be preserved, and yet the codes still need to be adopted and implemented by general purpose AI model developers. So based on your experience, what are the implications here if we aren't able to achieve this balance and general purpose AI model developers refuse to sign the code, for example?
Thank you for that question. And so my answer is very much based on not only the conversations with the GPAI providers, but also regulators, the same AI office, and other stakeholders involved in here. So this is more of a, kind of a balanced view. And before I delve into that, I think I would like to reply to some of the remarks that Dimitri's made. So I think in your first question, I think it's important to highlight that the AI Act is not specifically focused on US companies. EU AI Act applies also to European companies. It's tech and, country of origin neutral. And as I think, as you rightly mentioned, even European companies have some concerns when it comes to the commitments under the Code of Practice. And also the second point I think important to mention is that indeed there is such a wide range of stakeholders involved in this process. And actually, when you look at the numbers, the providers are very much outnumbered when it comes to civil organizations, civil society organizations, or other interest groups. So I think that there is a significant involvement of the public from very different ways of walk. So I think that there is a significant diversity. But I think that my overlying message is that we don't really have a choice. We have to make the Code of Practice a success. And I think that's because of 4 arguments. And the first one is referring back to my first question, is that it benefits a lot of different groups. And I think that alone necessitates making the code of practice a success, make it a realistic tool for providers to comply with, and also something which is beneficial to the downstream providers or deployers and the public as well. Second, I think this is one of the first AI Act tests in a way. AI Act contains many of these innovative regulatory tools, from codes of practices to sandboxes, advisory forums, the same, AI board. So there are different ways of involving the public. And I think that AI Act per se is very much a collaborative piece of law, which relies on that public involvement. So I think that this kind of first code of practice is a test for the EU AI Act, and we have to make it a success, and we have to be realistic as to what we are putting out into the outside world. The third point is that, as you mentioned, there are some concerns from organizations as to will they be able to sign to these commitments? And I think if we are working on this code of practice for such a long time, we should keep in mind the public administration resources as well that are being invested in this process. We don't want to make it a waste. We want to make this a success, and we don't want to waste public resource money and the human resources as well. And the fourth point, I think, is that there is a significant rethink in terms of EU digital policy, in terms of simplification agenda, and the various calls made by Draghi and Letta in terms of European competitiveness. I think we don't have the time to waste. We are at the very critical stage. So thus, it is important that this code works, and I truly hope that it won't be that scenario that everybody is unhappy with the code. I think that's definitely not the intention by any of the group involved in the drafting process, and that's why I think that we truly need to make it a success. But having those conversations, definitely we did hear some concerns when it comes to the code, especially, of course, with the very kind of administrative nature of the code and certain obligations that would further increase that administrative burden, which already exists in the EU digital policy and the applicable laws, as well as the concerns related to the code going beyond the scope and the requirements of the EU AI Act. That is definitely something which still needs to be streamlined. And frankly, the transparency requirements and the copyright requirements are also raising numerous concerns when it comes to the ability for organizations to sign to this code. While the third draft was published yesterday, and I can only talk about just snippets of having a look at that draft, I think we do need to recognize that the code has been streamlined significantly. I think we saw from the delay of publishing the code that the vice chairs and chairs took the time to carefully look at the overall code and try to streamline and improve it. And I think it's a Herculean task, really, and we mentioned that before, for all the chairs and vice chairs. And I think that we should definitely do a round of virtual applause for their efforts. But nevertheless, these concerns still remain. And again, if we want to make it a success, we should be realistic about it, and we should draft something which works for everyone, and especially for the ones that are developing the technology, which is still in evolving phase. It's very much emerging, and does require the flexibility.
Thank you so much for that, Lucas. I appreciate this notion that we need to make it a success. Absolutely. I mean, no pressure at all. But I think it is worth mentioning kind of the implications of if industry aren't able to kind of align and accept these codes. But I think you also raise a very interesting point about the implications of wasting resources in a very intensive process that could not necessarily yield the results that we're looking for, and potentially also increase administrative burden. So I do also want to kind of pivot a little bit away from industry towards the public administration. And we know very much that the adherence to the codes of practice is set out to be, like I said, a very key tool for general purpose AI providers for demonstrating conformity with the EU AI Act. But the obligations that are outlined in Article 53 and 55, especially for models with systemic risk, they really bring on kind of a unique set of challenges for providers trying to navigate these requirements. But this question is for Maria, having participated in AI board meetings where member states are really discussing kind of supervision and governance and enforcement mechanisms. What do you see as potentially the biggest kind of compliance hurdles for general purpose AI providers? And again, kind of shifting the perspective here to the public sector, how might these challenges impact public sector's ability to adopt and integrate AI systems effectively in the near or medium term?
That's an interesting discussion, and actually it's an interesting pair of shareholders, like the providers and the administration, having both problems with the GPAI code and actually with the GPAI models implementation into operation. So let's start with what's going on with right now. Right now, the most difficult place, the already manufactured GPAI models are in the most difficult place, because these models are already built. They already have some kind of functioning. They have some training. They already have some data sets into them, which we don't know, could be copyright protected, could not. You don't know. We don't know. It's still under examination. So these GPAI providers are in the most difficult position. Now, the GPAI providers generally, they face multiple challenges. I will only mention 3 of them. First, I would say that transparency, as important as it is at the same time the trickiest one, because it comes with documentation. And documenting the whole process to make sure that they are safely integrated into the downstream applications. This is the most difficult part, because you have to gather documentation from each part of the process, from the training, from research up to the reporting. Everything has to be documented, and we know that this helps in many aspects, but we know also that this is the most difficult one. I would go to the second one also in line of, I would say, difficulty. And safety and security concerns would be my second choice, because you can never be sure enough. Safety and security, we all know that they were not the first thing in mind for the GPAI providers. So now having all the safety measures to comply with must really make it difficult. Incident reporting and accountability. So this is also another part where you have a massive model. You have a massive number of data sets coming and going, and you have to take the incidents out, make the right categorization, report accordingly to the authorities, and make sure that you take into account every little reporting that you see, every little detail and fault in your system. And we're talking about systems that we have already been working, and we're talking about systems that are working all over the world. So it's not just a matter of data, it's a matter also of perspective around the world. How do they use it? So incidents can be anywhere on anything. That 3, I would say, are the most important parts. And now public sector AI adoption. That's also a difficult one. And why? Well, procurement complexity. How do you choose? How do you deploy the right model? How do you make sure that this model really complies with the regulation that you have to follow as a public sector, right? So public administration administration may struggle to navigate this landscape, potentially delaying AI adoption. So this would be the effect in the end, delaying. It will not, stop it, but it will delay the process. The second one would be the increased compliance burden. But I would also add, Lucas already mentioned that. I would also add the fact that it's not just the bureaucracy it would be created and papers to be drafted. It would be also the fact that public administration would avoid to create their own AI system. So it would take some risk approach for them to create such system, and risk aversion is something that is usually created when in public administration when something is uncertain. So unfortunately, the GPAI code might create hesitation to integrate AI solutions in the public administration, while of course the goal is the opposite, right? And but the result could be that. And what could we do to avoid that? Because I always would like to leave it with a positive aspect about what can we do about it. Well, training and information. Because if public administration knows what they are doing, navigating the GPAI code, the fear would go away, and they would know how to choose, how to have compliant GPAI models, how to negotiate terms in the agreements that the public administration is going to have with its GPAI models, because it's all about terms and conditions. In the end, it goes down to a contract that will be drafted between the public administration and the GPAI model provider. So that would be my take on this. Thank you.
Thank you so much, Maria. I think you mentioned some really important points here, and I think the one that stick out to me the most is truly the need for building AI literacy amongst all actors, but specifically public sector kind of officials, regulators, to be able to really fully understand kind of the implications of something like the codes of practice, and then also be able to react and respond accordingly. I mean, in the work that we're doing, we know, for instance, procurement officers need to be equipped with the right knowledge, the right questions to be able to critically assess these models that would be potentially adopted into the public sector. So I really appreciate your insights on that. And I think that kind of concludes kind of the segment really dedicated on the drafting process. As concluding thoughts on that, clearly more work needs to be done as we approach kind of the final draft. But I do want to move into the third and final segment of this panel discussion and kind of shift our focus to the broader policy and political implications that might be associated with something like the codes of practice. While much of our discussion thus far has really centered on the purpose and the development of the codes, it is also worth considering kind of the wider impact of them within the EU, but also possibly beyond. And so, Maria, I'm going to toss it right back to you. As public administrations work to comply with the EU AI Act, they're still awaiting some clear guidance, particularly when it comes to things like risk assessment, but also, as I've mentioned, procurement and additional kind of governance structures or measures, for instance. So how do you think bodies like the AI Board, which you're a part of, are supporting public administrations in this process? Are there any initiatives or mechanisms that you're aware of that are either in place or currently under development that are designed to kind of help support public sector organizations with the proper tools and knowledge needed to meet these new obligations and really be able to kind of adopt AI solutions in their work, both in the public administration, but also to improve things like public service design and delivery?
The AI Office, along with the AI Board, as you know, really are the coordinators of the regulatory landscape right now in the European framework. So what are we doing in the AI Board is trying to ensure that public administrations, through the participation of national representatives, have the tools and the knowledge to comply with the AI Act. How do we do that? What are the tools? What are the initiatives? First, it's the guidance. So what we're gaining there is guidance on specific matters and on compliance and risk management. So first, we try to recognize the risks and what are the possible scenarios in every subgroup that we're working in and I think 10 subgroups right now in different aspects. So in every aspect, we can recognize the risks and then try to focus on compliance and guidance on the risks. So what we already have done is providing some templates or some guidelines on specific matters, on use cases. Because, you know, AI cannot always be so vague and talking about AI. There are cases. So the AI board gathered these cases through the representatives. We all gave our own opinions, legal experts and other experts, technical experts, and the AI office provided their opinion, and altogether we found out some solutions to the use case problems. So the second one would be the capacity building and training programs. So for now, I know that there are thoughts of how we could give the feedback, how can we transfer the feedback that we are receiving inside the AI board outside to the state, the shareholders that are interested in this feedback, like companies or national authorities that are not participating, because, you know, in the UAI board, we cannot be, you know, there's not everyone. It's just one representative for each country and one tactical and non-tactical, and that's it. So what we have to do is transfer this knowledge outside of the AI board. The collaboration and knowledge sharing is the third pillar, which comes down to what each country does. So we're on a table and asking each other, so what are you doing? And what are your problems? Of course, if you sit in that table, you can see that there are so many different problems based on the social situation and the economic situation of each country that are really hard to imagine for every country. So bringing their own problems help us think through the future and then provide guidance for the future. So collaboration, sharing, and sharing best practices. This is one way that the AI board works, and we have to draft down the best practices in our countries and share it with each other. And that's a very useful exercise. And the last one is accountability and oversight. So a last part after, let's say that we issued the guidelines, issued the codes of practice. So the last part would be monitoring. What are we doing? How are we doing? How is this going? Do these guidelines really work? Or do we have to change some things? So monitoring and alignment is one of the main goals of the AI board. I would say that it's a very, very interesting instrument because for the first time, the national authorities are there to discuss on specifically AI-related problems and solutions. And that has a really practical impact, and that helps, I think, everyone in society.
Thank you so much, Maria, and truly great to hear that you know, the experiences of national authorities are being kind of used to help advance kind of conversations and ensure that the AI board is constantly monitoring kind of advancements, but also remaining agile and flexible in, you know, new emerging challenges that different member states are facing. So really happy to hear that, and I know you have another meeting coming up towards the end of March. So always looking forward to hearing kind of advancements and updates from the AI board. Thank you so much for that. Now, I do want to move on to our next question. So one of the key kind of discussions surrounding the codes of practice is very much their scope and how they diverge from the EU AI Act in some ways or another. While the AI Act provides a very clear kind of legal framework, the codes have taken a more flexible approach, which some have argued sometimes adds more complexity rather than clarity. So especially for industry or public sector actors who are seeking to comply, there may still be some legal ambiguity or some confusion. So given this, Lucas, do you see that the codes of practice are a useful mechanism for simplifying regulation within the digital policy landscape? And from your perspective, what improvements do you think are needed to make the codes more usable for their intended audience? And what kind of changes would you like to ideally see in the final draft expected for May?
Thank you. So first of all, I think perhaps I would just make that distinction between the AI Act and the Code of Practice. I think that it's important to keep in mind that the AI Act essentially is a product safety legislation. It's not a fundamental rights-based legislation like GDPR, which per se means that, you know, these obligations and the way that the text is drafted is very different. So, you know, the same product safety legislation applies, you know, to kind of household items, you know, from fridges to toys, etc. And we're using the same for AI in this regard. So when it comes to the code of practice, I think generally the code of practices and certifications, sandboxes are the tools that we should be promoting as much as possible. These are the tools that are outcome and risk-based, and particularly for technologies that are so rapidly moving and evolving, we need that flexibility, and we do need outcome and risk-based rules. That also certainly implies that not every single model is the same. That's why we need the risk-based approach, so that organizations will be able to choose their mitigating measures, etc., that are appropriate and proportional to the model. And I think that's definitely a crucial element to keep in mind. So actually, my full support goes to these kind of innovative tools, and I think that we should be using more and more of those. When it comes to the third draft, it is definitely moving towards this direction more and more in terms of being more principle-based and outcome-based and more proportional. However, there are still elements that are prescriptive in terms of these obligations. So perhaps that would be my one of the items on the wish list for the upcoming fourth and final draft, to try to certainly kind of move away from these prescriptive elements. And I think that you very rightfully put it into the overall context that we have here in the EU in terms of the digital strategy, and the shift towards simplification and focus on competitiveness. The outcome-based rules and risk-based approach does not imply that organizations are solely self-regulating and self-monitoring themselves. These are still legal mechanisms that signatories adhere to, and I think that's very important to keep in mind. And secondly, I would go back to the statement that I said before, that we need to make this a success. And I think, again, that very much fits within this competitiveness message. And the way we regulate technologies. I think that Draghi raised a lot of concerns when it comes to the current status and the way we approach technology in the EU. And I think this is a good chance to be more outcome-based, more risk-based, and less prescriptive, and allow the flexibility and agility for organizations and everyone and all the stakeholders involved. And I think that that's something that the AI office, frankly, has in mind, because the state of the art is moving essentially every day. And the AI office does have the opportunity to further specify the code of practice and adjust it depending on the state of art. So I think it's important not to keep it too prescriptive. So the rules are future-proof, and we don't have to come back to the same code of practice in a couple of months just because it's going to be outdated.
Thank you so much, Lucas, for outlining kind of your wish list for the next, for the final version of the codes of practice, but indeed kind of highlighting the necessity for it to be almost a living document that can be regularly updated as needed. I'm sure you, like many others, will be submitting your feedback before the 30th of March deadline, and I encourage others online, if you would also like to send your wish list, to do so before March 30th. Now, I'm going to move on to the final question of our panel, Demetrius. I really want to conclude kind of this segment and this discussion by exploring the implications of the codes beyond the EU. Unlike the AI Act, which is legally binding, the codes of practice are considered a voluntary instrument. In their non-binding state, it can be argued that they still hold considerable weight as a compliance mechanism, possibly serving as a global reference point, influencing AI regulatory discussions in jurisdictions beyond the EU. However, there is also the possibility that these codes are eventually granted validity by the European Commission via an implementation act, which of course carries some legal implications for developers of general purpose AI models. So given the codes of practice's potential to serve as an implementation act, how do you see their evolution shaping future regulatory enforcement, both within and outside of the EU? Do you see them possibly becoming a blueprint for structured co-regulation and AI governance, much like we saw with the GDPR for data protection? Or do you kind of anticipate a divergence on how other regions will approach AI oversight with regards to a system or an approach like the codes of practice? Thank you.
Well, Michaela, the truth is that we're actually facing a critical juncture here. And I'll take a step back and not necessarily talk whether the code of practice affects someone's profits or someone's intellectual property or is discriminating. I'm talking about the nature of this technology, artificial intelligence, coupled with its very rapid evolution. And that demands a response which is far beyond our current capabilities. Artificial intelligence has the potential for catastrophic misuse, even for escaping human control. And if you think that this is far-fetched, please check out the latest research, which was published by OpenAI, and they were red teaming these models that you are using yourselves every day. That was O1 and O3 Mini. And it showed that these models were cheating in chess and they're deceiving their users. And even when they were told, look, we have caught you, they went on cheating, but they were hiding it from their supervisors. So we have an AI Act, which is now set, but AI challenges have rapidly moved, even in the last few months, certainly since the AI Act was actually finally voted. They have moved so quickly and far beyond what we have seen before. So, in fact, some experts have suggested that we only have until the end of the current year to enact risk-proof policies. Otherwise, the subject will become too complicated, too fragmented, or even incomprehensible to us. So the code of practice was seen as the last chance to create a framework for AI safety. You see, it is not an implementing act, which meant that we did not, the drafters of the code of practice did not have to restrict themselves to what the AI Act was doing. Now, of course, it could be as narrow or as broad as the consensus would be. But especially after the resounding failure of the February Paris AI Summit to address AI risk, short-term and longer term, everyone, and that's no exaggeration, is eagerly awaiting for the EU to use the code of practice in order to stand its ground against the Wild West espoused by some big tech and to show us the way forward towards a safe and beneficial AI. We should not forget that the EU AI Act is the world's first and only so far comprehensive AI law imposing legally binding rules to high-risk systems and frontier systems. And its influence has already transcended European boundaries. Small example, what happened in California a few months ago with that bill SB 1047, which ended up not passing because, come on, California, you understand who might be lobbying there. But it was actually its drafters said, we have been influenced by the AI Act and the contents of the code of practice. So what I've just said are the distillation of my ideas after several months of being part of the trials and tribulations of the code of practice drafting plenary and 2 of its working groups. From my side, at least, this is what I wish for our audience attending today to understand, reflect upon, and remember from this roundtable.
Thank you so much, Demetrius. And thank you all to our panelists for your really insightful contributions to today's panel, and also for staying on time. It's additionally appreciated, which means that we do have enough time to shift into a Q&A period. From what I understand, there has already been some conversation stirred up and some questions that have emerged. For this session, I'm actually going to turn it to my colleague Leila, who will be moderating this session. So Leila, I invite you to take the floor and kick off our Q&A session.
Thank you so much, Michaela. Hope you can see me now, almost. Thank you. Thank you, Michaela, and thank you to our speakers for the very insightful discussion so far. We will now move on to the Q&A section. So we'll hear from our panelists in response to questions from the audience. So if you have any questions for our speakers, please feel free to send them in by the Q&A function if you haven't already. But for now, we can dive in and start with a question addressed to all three of our speakers. So as we already talked about, and we already mentioned quite a lot, the third draft of the Code of Practice has just been released yesterday, marking another step in the ongoing effort in establishing a voluntary yet very influential guideline for GPAI providers. So to all of our speakers, we would like to ask, what are your first impressions on this first draft? We know it's super recent news, but is there any initial thoughts or reactions that you would like to share with us in a very quick 1-minute comment on the matter? Maybe Lucas, you would like to start, followed by Demetrius and Maria.
Certainly, and thank you. Thank you for this question. I think what I mentioned in the beginning already, these are just very initial reactions. But so having that initial reaction, I think from the first glance, it's definitely an improved draft. It's much more streamlined. There are certain elements that have been removed, which I think have been a bit too prescriptive. We can think of the specific KPIs, etc. But again, once you start looking at it into more detail, I think that the transparency measures still go beyond what I think would be proportional and effective as well to individuals in terms of receiving and understanding that information. An important point to mention, and something that we have across the EU law, is the protection of trade secrets. We should not risk the fact that transparency measures could actually risk exposing those trade secrets. From the configurations of the model and certain parameters. Of course, there is a certain level of transparency which is expected from actually any organization, everybody supports that. But those measures should not come at the expense of organizations that are developing and investing numerous, labor efforts as well as monetary investment. So that is definitely important.
Thank you. Okay, yes, Demetrius, if you can go ahead with your comment.
The third draft is quite disappointing in what regards protection of rights, both human rights, intellectual property, and social rights, and in what regards its risk assessment, risk mitigation, and coordination. In fact, crucial aspects of the second draft have been watered down considerably. Number one, we have almost no pre-deployment reporting required any longer, which means that providers can deploy risky models first and answer questions later. Remember what I mentioned in the very first question, that this was a missed opportunity from European companies to actually transfer the burden of all these bureaucratic things that Lucas is referring to, not to the Europeans, but to the providers. And what we are going to do instead is play catch up and drowning in paperwork for our own companies, which are basing their models on the GPAI models coming from abroad. Whistleblowers protections, which were very strong in draft 2, have almost completely been removed. And without updates specifically for GPAI, the EU whistleblower directive is inadequate. And the risk taxonomy dangerously leaves out threats to critical infrastructure, and mass discrimination has been removed, and mentions absolutely nothing about significant misuse and further risks, longer-term risks. So as I said, it is going to, the mother of all battles is going to be fought in the plenary from now on, and we will see what happens.
Thank you, Demetrius. Maria, please.
Yeah, sure. What I understood from my just first reading is that the market was heard. So the main goal of the GPAI code and this inclusive procedure was accomplished. So really, the complaints were taken into account for the better or for the worse. But it was really the industry was heard, and this is so important for Europe to showcase their dedication to have innovation ahead. The second thing I would mention for this draft is that the copyright obligations are really clearly stated there. So the previous draft has the copyright obligations already in place. They are a main part of the commitments of the GPAI providers, but now they seem to be in place, categorized, and that's what I like as a lawyer, to have the obligation, straightforward, 1, 2, 3. What you have to do is this, and not generally, protect and respect. So that would be just my 2 cents for this draft. Let's see for the next one.
Thank you to everyone for your insights. You touched upon very different aspects, but one thing you all agreed on is how different this new draft is from the previous one, and how this will make for a very interesting last plenary. We will see how that plays out in the future. Now moving to some more specific questions. Maria, our audience is very interested to know a bit more about the enforcement aspect. So we touched upon the commitments and the areas covered by the code. We discussed about how centralized bodies like the AI board can aid public administrations in compliance. But when it comes to the code specifically, how would enforcement of the obligation brought forward take place, also considering it is a voluntary code still?
Yeah, that's a big discussion that's going to follow the GPAI code drafting. And actually, we're expecting guidelines from the AI office to be issued on the enforcement, and both for the next models to come and for the previous ones that already work in place and operating around us. So enforcement has been a long discussion. The thing is that we don't want to scare the innovators, so we're talking about the GPAI, so voluntary soft law. But at the same time, what we're saying is that if you follow, and what Demetrius also mentioned, if you follow this code, then there is a presumption of compliance. So that means that if you don't follow, then the presumption of compliance is not there. The compliance, the authorities would assume that you assume that you're compliant. If you don't follow the rules, that means that you might have an audit, a down raid in your company systems, and following this audit, the AI Act obligations would be enforced, because AI Act is really strict, is really obligatory. It goes to everyone. So I would think that the enforcement of GPAI codes would pass through the AI Act and through audits. There is no preventive, the preventive action is not that strong, but the next stage is going to be stricter. And my belief is that it all depends on how strong are the technical audits in Europe are the technical audits going to be? So each country would have their technical audits. I know that there is an enforcement subgroup in our AI board, has a subgroup dedicated to enforcement. So that means that authorities have to check the systems and the models. And that goes down to, technical abilities and willing and power to enforce AI Act and the codes of practice.
Thank you very much, Maria, for laying out the framework that will be happening. So basically, we understand that enforcement as a whole drafting process is very much a matter of balancing interests of different parties. And this brings me back to Lucas. So referring back to your first answer in the first segment, you mentioned how models with systemic risks are oftentimes also the ones bringing the most benefits. So from our audience, we have some arguments of would it then make sense to shift towards actively encouraging technical research like mechanistic interpretability research, for example. So there's a risk of providers merely treating compliance as a tick box exercise, but this won't prevent them from trying to conceal and obscure undesired behavior. So should a code explicitly require investment in interpretability research above current efforts to bring the focus on how models reason rather than just optimizing for regulatory approval?
Thank you. I don't think that I'll be able to provide a very definitive answer in terms of, research surrounding the mechanistic interpretability. But frankly, I don't think that this is just a box ticking exercise and just mere compliance. I think what we see in terms of these public facing documents, that's already a result of numerous iterations and different approaches and research that the companies and organizations invest in explaining their models. I presume that there can definitely be more in terms of explainability, and I think that this is a very fast-moving field. What does it mean to really have effective and meaningful transparency and explainability? I don't think that we have, the best practice yet, and the best practices are evolving there. But I think that certainly we will reach that stage. And again, I think this is not just a box ticking exercise. From having numerous conversations with organizations, there are specific teams devoted just on the code of practice and then complying with that. And I'm not talking even specific teams just for the AI Act compliance. So there are, numerous staff members involved in just making sure that organizations can comply with this code, and they're investing a lot of money and resources in that. And I think coupling that with the enforcement of the AI Act and the fines that are coming with the breach of the AI Act, I don't think that companies are seeing it as a mere compliance and box ticking exercise, because there is just simply too much to there is too much on the scale.
Thank you, Lucas, for sharing your nuanced perspective and also to bring it to us the perspective of the providers as well. Now let's move from this very specific perspective onto the outside world. So back to the metrics with considerations about the situations external to the EU. So should the EU use this momentum from expected changes in funding priorities in the US, for example, and also mandatory AI regulatory sandboxes to attract key talent into the European landscape, for example, like AI safety researchers or for what concerns scalable oversight? How do you see this aspect of attracting new talent developing in the near future? And what role do you see the codes also playing in regards to this opportunity? I'll take it to you, Dimitris, and then we'll go directly to Michaela for some final remarks.
The code of practice only tangentially would affect the attraction of talent. what that means is if it was made so onerous for the providers, then I think that's possibly talent might say, well, I'm not sure I want to work with them. On the other hand, what we have said is that it does represent a missed opportunity. Of course, we need to find a compromise point. Of course, we need to ensure that the European ecosystem not only survives but thrives. But if we do not take into consideration the medium and longer term risks, not only the short term risks, then this is something that we're going to regret, possibly.
Thank you. This marks the end of the Q&A section. Thanks to all of our speakers, Lucas, Maria, and Demetrius, for engaging with us today in this discussion on this code of practice. It was really interesting. You brought a lot of new ones, and we really thank you for participating in this with us. So back to Michaela for our closing remarks.
Switching over. Indeed, that was a very engaging discussion, both in the panel, but also in the Q&A. So thank you also to our participants for submitting your questions, and for our panelists for being able to provide these insights. So as we conclude today's event, again, I want to just extend a huge thank you to our esteemed panelists, Maria, Lucas, and Demetrius. Thank you so much for sharing your insights and your expertise with us today. I do want to just take a quick second to underscore some of the key takeaways of today's discussion. In general, the codes, in my opinion, have really marked a significant step to AI Act implementation, providing a preliminary compliance tool for general purpose AI developers. Despite these being specifically for this audience, for these signatories, today's discussion, I think, really has highlighted that all stand to benefit from the codes of practice, for increasing transparency, trust, and awareness on the state-of-the-art AI models that can really have profound effects and influence on public life. The future of the codes remain contentious, I think. This is unsurprising, since the codes represent, again, a real significant opportunity to advance AI safety here in the EU, but also potentially beyond. Nevertheless, it is very clear that in order for downstream providers to really benefit from AI innovation, additional support, guidance, and capacity building is truly needed, both for understanding and interacting with the implications and the outputs of the codes of practice, but also for more broadly, general responsible AI adoption in different sectors and in different areas of life. So as we anticipate the finalization of the codes, again, expected for May, we here at EIPA remain extremely engaged and committed to supporting ideas of AI literacy and governance, and truly remain hopeful that the frameworks that we establish here in Europe will really steer the development and the deployment of AI in the direction that, again, benefits all. If you, our audience, feel compelled to have your voice heard in the drafting of the codes of practice, you do have until May 30th to submit your feedback. Should you be interested in following developments on the codes of practice or EU regulation on AI more broadly, I encourage you all to check out the work that EIPA has been doing. We recently published a blog about the codes of practice on drafts 1 and 2. And we will be delivering a training specifically on AI risk management in the EU, where we do discuss in more detail the measures and the mechanisms for complying with EU regulation, specifically relating to artificial intelligence. In the meantime, I thank you all so much for your active participation and thoughtful contributions. We really hope you enjoyed today's event and hope to see you again soon in our future events and trainings. But for now, we wish you all a great rest of your day, and thank you again for joining us. Take care, everyone.